Our next speaker is David Galwey, who is the Director of Tree Dimensions, a Melbourne-based consulting arborist. David assists the arboricultural profession in several ways, providing arboricultural advice and guidance to local government and other clients. He also sits on the New South Wales Land and Environment Court, adjudicating on tree disputes between neighbours, of which there are so many that New South Wales has got specific legislation on those issues. And he lectures at Burnley. David's topic this afternoon is Love Thy Neighbour, private and public trees in their legal context. Please welcome David Galwey.
Thanks, and thanks to the Garden History Society for organising this wonderful day and for inviting me along to speak today. It's a privilege to be among such esteemed company. I was lucky enough to be a student at Burnley when it was under Greg's gentle and highly scientific leadership. But what impressed me most today so far is not his science, not Greg's science, but his use of the word awesome to describe a tree. Greg denies completely that he's on social media, but I think keep an eye out for hashtag trees are awesome. So yes, I run a small consultancy business in Melbourne, but that's not of interest to you. I'm also an acting commissioner at the New South Wales Land and Environment Court, and as Stuart mentioned earlier, Judy Fakes is also a commissioner at the court, and some of you, probably lots of you, know of Judy. She may well have been here today, except the court's conference is on this week. And so we couldn't get her, or somebody couldn't get her down here, obviously. I was at the conference yesterday, and the Chief Judge of the court presented a wonderful paper on valuing the economic value, putting economic value on the natural environment, on natural resources. It was a really worthwhile paper, and for all of those of you who have spoken today on that subject, it's a paper I can, with his approval, share with you. It's very interesting. I think we've seen a very simple story unfold today, and it's a story that goes something like this, which is lifestyles have changed, economic pressures have changed, and we now see new suburban developments with very little open space on private land, and we see older suburbs being pressured, their open space being pressured by infill development, and all of this puts greater pressure on trees in the public realm. You've seen that there's positive stories here, Brisbane and elsewhere, other cities in Australia, where our tree managers are responding very positively to that challenge. But it doesn't take the pressure away from trees on private land. I found Tony's pictures, especially those aerial images, quite startling. And it's easy to be nostalgic for the suburbs that I grew up in Australia. But I don't think nostalgia works. I think nostalgia is a bit defeatist because it's saying that change is for the worse. And I actually think change can be for the better. And I suppose that's my thesis that I'm going to put to you today, which is change can be for the better. And the example I'm going to use is, because all stories have villains and heroes, most of the heroes are gathered here today, but the villains, the planners, the engineers, the villains, sometimes law is seen, I suppose, as a villain, and certainly many people have cynical views about the law, but my experience at the court is that the law can do a lot to actually help us in our mission to have more trees in cities. I haven't cleaned my gutters for a little while. And in the huge rains we had, my gutters flooded and my ceilings rotted, got all wet and rotten. So do you think I could sue my neighbour? Yes or no? And then the next day, my tree fell on the neighbour's house. It's been a bad week. And now the neighbour wants to sue me. Do you think they can sue me because my tree fell on their house? Yes or no? And we all know that surely we can prune up to boundaries, overhanging branches up to boundaries. We all know that, don't we? And that's actually a caption competition. I want you to tell me what the hell is going on there. My best so far is something about the law as an ass, because I'm talking about trees and the law. But actually my thesis is it's not an ass, it's a healthy horse, the law, looking into trees, and perhaps, something that can help us. I want to give you a little background about trees in the law first, or just a picture of how long trees have been considered in the law. And this is from the Babylonian Talmud, somewhere between 3rd and 5th century. And it's about trees and overhanging branches. So we've been thinking about these things in a legal context for a long time. I'm not a Babylonian Talmud scholar, so if I've got this wrong, let me know. Back in the late 1800s, an English lawyer decided he would go and have a look at the history of trees and the law. And he took a few months off work, which turned out not to be enough, and he collected a lot of case law about trees and wrote a book to help his legal colleagues when dealing with trees and the law. What the preface explains is that it took him a long time. And as an example, here's the cases that he's looked at and quoted, and we're only up to the letter C on the first page. He looked at a lot of cases, so even in the late 1800s, we had a lot of case law about trees. Here's the bit that I want to stress to you, that even back then, trees were valued. The value of the public benefit of trees was being considered in the law. And what he said is, the tree owner, somebody who owns trees, a landowner with trees, will even find that the enjoyment of the most absolute right to trees is subject to some minor liabilities for the public advantage. So even then, we've got this concept that trees, even on your land, are for the public good. And I think that's worth noting. He also talked about the punishments that might fall to people who went against the law and who harmed others' trees. And there was one act that dealt with this and declares the punishment of simple larceny to be penal servitude for 3 years, imprisonment for 2 years, hard labour, with or without solitary confinement, and if a male under the age of 16 years, with or without whipping. They were the days. In Australia, we have various laws that protect trees, from the national public realm, such as national parks, down through state legislation, local government legislation, which is part of state legislation. And we have trees dealt with under common law as well. So the ones higher up this list tend to deal with trees on public land. As we get down the list, some of those still deal with trees on public land, but also with mostly trees on private land. Local laws that protect trees. In Melbourne, some councils, not all councils, have local laws to protect trees. It's a Bayside's local law. And a person must not, without a permit, do certain things to a tree. And a significant tree is a tree that's either on their significant tree register or is a tree above a certain size, usually trunk size. Yarra's local law, City of Yarra is just up the road. Local Law 3, again, a person must not, without a permit, do certain things to a tree. The difference with Yarra's, and this is interesting, is that the requirement to obtain a permit does not apply when adjacent landowners want to prune overhanging branches. And the other day I was called to look at a tree in the City of Yarra, and somehow a large old red gum on private property that had made it this far without being on any significant tree register and without even being on council's radar, which was, I thought, interesting. And the tree showed signs of declining, let's call it, perhaps poisoning, but nobody knows that. but the tree started declining, and the owner of the tree cut the tree down, or started cutting the tree down, and it's a bit tricky with red gums to know how old they are, and many arborists will argue very different things, but you've heard Greg talk about some red gums being much older than others, than some arborists were saying they were, and certainly the trunk on this tree suggests that it was a very, very old tree, and that's as far as I'm willing to go. But it was a very old tree. And it was half cut down before council got there. Remains of it are still standing as they work out what to do. Interestingly, under this local law, because the tree stood in the corner of the property and its spreading canopy hung over 3 adjacent properties, the adjacent landowners did not need a permit to cut off the bits that were over their property. So even if the law had not been broken, this very, very old red gum, indigenous red gum, could have had 3/4 of the canopy cut off by neighbours. So the local law protects trees up to a point. For those of us who like still having trees on our own properties, if we get involved in disputes with our neighbours and trees are up there with dogs, fences, noise as the highest causes of disputes between neighbours, typically what you'll do if you get involved in a tree dispute with your neighbour is you'll end up in the magistrate's court, and you might need legal assistance, and it might be a bit of an expensive exercise. It'll be dealt with under common law, so it'll be dealt with usually under the tort of nuisance, and the magistrate, who's just heard a matter about drunk driving, and then had a matter about shoplifting, and then a matter about some young person taking drugs, is then dealing with your tree dispute under common law, and that's the way it works. In New South Wales in 2006, they enacted the Trees Disputes Between Neighbours Act, which deals with, specifically, tree disputes between neighbours. When an act comes into being, it's as you've no doubt read about lately, because certain acts are coming, or at least being proposed in Parliament. When an act's proposed, it gets put up, there's a second reading from a minister, and it makes its way through. At the second reading speech for when the Trees Act was being put forward, Minister Debus, who you've already heard about today, and he was the Environment Minister in New South Wales at the time, said they provide energy, this is trees, provide energy savings through lower cooling costs, etc., all the benefits that we know of. The bill therefore recognises the environmental contribution of urban trees as a factor that the court must take into consideration in determining applications. So when we go back to the magistrate's court and a magistrate hearing a tree dispute, there's nothing to guide that magistrate. There's nothing saying he must consider these things. And a lawyer for one party might say, well, you have to consider the benefits of the trees. And the magistrate might say, well, why do I have to? And the lawyer would argue why. Here, there's no doubt about it. Whoever is hearing this matter, a matter under the Trees Act, must consider the benefits, environmental and social benefits of the tree. So I'm just going to show you a couple of bits of the Act so you can see how it works. Section 7 of the Act says an owner of land may apply to the court for an order to remedy, restrain or prevent damage to property on the land or to prevent injury to any person. So it's only about damage or injury, that's all it covers. And the tree must be on adjoining land. And so far that only it doesn't include Crown land, it doesn't include council land. So for all you council arborists, you'd be relieved to know that you could not be, if you were a council in New South Wales, you could not be taken to court under this Act. It's interesting because in the second reading speech, the Minister actually said that when the Act would be reviewed, and it's already been reviewed, so that was in 2006 he said this, when the Act is reviewed in a few years, it's envisaged that trees on public land will be included. I think it's a political decision. I think the reality is if everyone could have a go at the council tree out the front of their property, the court would be inundated. And I think that is as simple as that. That is why it's not in there. when commissioners of the court, when the court is making a decision on hearing and making a decision on a tree dispute, there's jurisdictional tests that must be met. If they're not met, the court can't make any orders. So when I hear a dispute, and the disputes, the matters are usually heard on site. Sometimes we're in court, but we usually start on site. And so the good thing about that is you've got an arborist there, and the arborist is looking at the tree, and that is a big start. And unless the tree has caused, is causing, or is likely in the near future to cause damage to the applicant's property, or is likely to injure a person, the court cannot make any orders. So we have to be satisfied of that first. And the kind of orders that we can make can be for pruning, removal, other tree work, so cabling, root pruning. No, not whipping. Payment of cost for works, so getting quotes for things to be fixed, buildings to be fixed, compensation if a building's already been damaged and has been repaired. Some of these claims can be quite large in the size of the claim. And for ongoing tree works, we can make orders that a tree that has overhanging branches, for instance, that it be pruned every 2 years to remove dead wood above a certain size, dangerous branches, things like that. This is a bit, I don't want you to read all of this, but importantly, there's a section of the Act that says these are the matters to be considered by the court. Okay, so if those jurisdictional tests are met, we then have to consider a range of matters. And I'll point you to a few of them. And that is the impact of pruning, that pruning would have on the tree. So you can't just say, well, prune it. Think about what that might do to the tree. Any contribution of the tree to privacy, landscaping, garden design, heritage values, or protection from the sun, wind, noise, smells, or smoke. Historical, cultural, social, scientific values, local ecosystem and biodiversity, soil, erosion, scenic value, public amenity. These are all things that the court has to consider, and will usually hear from the parties on these issues. Also further down, any steps that the applicant has taken to deal with the damage. That is, if the applicant's been aware of it, hasn't gone next door and said to the owner of the tree, your tree is damaging my property, has not done anything about it for the last 5 years, and the damage has got worse during that period, the applicant won't be getting compensation for anything during that period. When the Act was reviewed in 2009 and then the revised Act put through in 2010, it was decided to include hedges. And this is the first time that any court in Australia has dealt with the not right, but the ability for a landowner to have access to sunlight and views, and for the impact of neighbouring trees on the access to sunlight or the access to views. And it's an interesting area because, as you can imagine, Sydney has some stunning views. We wouldn't have this part of the Act in Melbourne, would we? Oh, okay, or maybe some people along the filthy Yarra. That includes me, by the way. And this is where you're more likely to get barristers involved. The Act was set up to be cheap, quick and just, I think is the punchy catchphrase. And so it's $220, I think, for an applicant to make the application to court. The time frame is usually from application to having a decision is a matter of months, and that's going through the whole process of a pre-hearing, directions hearing and all that. So it's generally pretty quickly, it happens pretty quickly, and it's also set up to assist people be self-represented. So you don't have to go out and get a lawyer. It's actually, you've got an arborist coming out to look at it, and unless you need some more complicated, maybe a climbing inspection of the tree, or some engineering advice, or something like that, you'll probably just represent yourself and there's no experts there. And probably over half of the cases we hear are self-represented parties. As soon as you move into the world of Mossman Harbour views and the neighbouring hedge, you're more likely to get solicitors and barristers involved. And so There's quite a few hearings that we have where we have barristers arguing about access to sunlight and access to views and neighbours' hedges. Interestingly, it's not to gain a view or gain sunlight that you never had. If you buy a property and the hedge was already there when you bought it, you cannot gain sunlight or views that you didn't have previously. So it's only about restoring something that you might have had and that a hedge has grown up to obstruct. Again, this tells you what the Act applies to with hedges. It's got to be a group of 2 or more trees that are planted, that is, they're not self-sown trees, so as to form a hedge that can be argued about and is, and rise to a height of at least 2.5 metres. And the clever respondents cut their hedge to just below 2.5 metres the day before the hearing. And again, this tells us when we can or can't make orders, and we have to be satisfied that the hedge is on neighbouring land and that it is severely obstructing a view, that is severely, and so we have set the bar high. So this is not an easy thing for people to prove, and it has to be a severe obstruction of a view. There's been some debate about whether, I guess some submissions have been made by parties that the view has to be a high value view, because in other planning matters, not involving trees, but planning matters that might involve building and blocking your neighbour's view, or building out a view, often views have been rated according to whether it's iconic Opera House, Harbour Bridge, or high value harbour, water, land interface, or just a low value view. My view when I hear these is that if you're out in Mount Druitt, or what's the suburb on SBS at the moment? Mount Druitt, Macquarie Fields? Anyway, out there, Rudy Hill, wherever we are out there, my view is if somebody has a view out their window of just the landscape, some sky, some rooftops with a few trees in between, that is a view. And it's not worth any less to that person. It's not the harbour, but that person can't afford a harbour view. So if their view is obstructed, as long as it's severely obstructed by a hedge, they may well have a cause for orders to be made. Again, there's a range of matters to be considered, because as you know, a lot of you are garden buffs, and you know the value of a hedge in the garden. And a hedge can be an integral part of a garden landscape. And so we have to consider all of these things. And privacy is often talked about in hedge matters, because privacy is aided by hedges. So coming back to my gutters and my flooded ceiling, so I take my neighbour to court because it flooded, my ceiling got wrecked, it cost me $3,000 to fix. What would the court say, do you think? Why didn't you clean your gutters? Very good. You should come along to the court. In fact, not only did it say it, but the commissioners who heard this case, Barker and Kyriakides, took the nerve to set down a principle. And a principle is just, well, it's not just that you're quoting somebody else's decision, but here's a principle that will remain. That is, it's a level above just a paragraph in a judgment. So people can refer to this and it's got some weight. What it says is for people who live in urban environments and enjoy the benefits of trees, some level of maintenance should be expected. And the last paragraph says, the dropping of leaves, flowers, fruit, seeds or small elements of deadwood by urban trees ordinarily will not provide the basis for ordering removal of or intervention with an urban tree. And so far, I mean, you can imagine we have lots of cases where people say there's leaves in the gutters, there's leaves on the paths, it's excessive cleaning up. And some of these trees are large gum trees, for instance. So far, we have not had any reason to veer from this principle. So there's been no exceptional circumstances where we would veer from this principle. The principle got extended in a case where they were claiming that mould was on the paths, and that was there was a risk of injury because they might slip over, and again, the principle got extended to say, well, the maintenance might include scrubbing of your paths. Soon after the Act came in 2006, in fact, it was those really big storms when Newcastle got a thrashing and the ship got stranded. A tree on private property fell on a neighbour's dwelling, causing considerable damage, but luckily not any injury or worse. And the owner of the damaged dwelling took the owner of the tree to court to try to get the cost of repairing the house. The Chief Judge, Chief Justice Brian Preston, went out to hear the matter, so with the aim of writing a very lengthy judgment to set down a whole lot of precedent that could be then used later in following matters. And he did write a very, very lengthy judgment. And it's a ripper. And just like that book before, I showed you that book where a lawyer had looked into the case law present in the late 1800s, what Chief Justice Preston has done is looked at all the recent case law around things, issues about public or private trees. So there's many cases referred to, and it's if you ever have trouble getting to sleep at night, it's a good thing to take to bed with you. And you'll learn a lot. You'll learn a lot about trees and the law. What he said when in making his judgment was, and as I say, it was a very lengthy judgment, and it's only when you get down to the very, very end that you read. However, the mere fact that a tree is situated on a person's land is insufficient reason by itself to justify making that person an insurer of other persons for any harm the tree may have caused to them or their property. In the law of torts, fault provides a reason to shift the incidence of loss. A person who is at fault for the damage or injury to another person or their property is punished by being compelled to make pecuniary compensation to the person so injured. On the facts of this case, however, I have found that Mr. Leshke is not at fault for the tree's failure. That is, it was a large indigenous gum tree. He had no knowledge of anything wrong with the tree, and nor should he have been expected to. So he wasn't at fault for the tree's failure and the consequential damage to Mrs. Robson's house. There is no justification to order that Mr. Leshke pay compensation to Mrs. Robson. The tree did not solely benefit Mr. Leshke. The tree made a contribution to the local ecosystem and biodiversity, the natural landscape and scenic value of the locality, and public amenity. This is a tree on private land. The tree was able to be seen and enjoyed not only from Mr. Leshke's land, but also from Mrs. Robson's land, as well as by residents and passers-by in the neighbourhood. In these circumstances, the justice of the situation is to leave the loss where it falls, namely on Mrs. Robson. There's also another principle that the tree was there first. So if you build a house and there's already a tree next door, and this I find very positive when we start, I can foresee, we've talked about slabs near street trees, and I can see a world not all that far away where homeowners will be expected to allow in their building for street trees, whether the street trees are there yet or not. So the court has decided that if a tree is already next door and you build something, that you might want to consider the effects that might have, what the tree might do, what the impacts of having that tree are. And there's a couple of cases, I put them there, where that was considered. And in Black and Johnson, it just lays out that the fact that the tree was there first is a consideration. So we all know that under common law, we can prune up to the boundary, don't damage the tree, chuck the branches back over the fence. Trees on boundaries might be tricky things. The difference between common law and statutory law is that common law, I guess, evolves slowly over time. It's just judges making decisions and it evolves. Statutory law puts it in writing, and sometimes you get a big jump ahead. The Trees Act in New South Wales is certainly a big jump ahead. There's common law history about trees on boundaries and who owns them, who's responsible for them. We've had some cases in the court where we've had to work out which land the tree was principally on, and a survey came in for one matter like this, but that was taken some distance above the ground, and we reordered it, and that is a very detailed survey taken at ground level of the tree trunk, because that was important in this matter. It's not always important, but that was important in this matter. Interestingly, we, as many other courts have done, generally work out tree ownership or location of the tree based on where it emerges from or joins with the land, the soil. However, in Canada, not all that long ago, a judge, Justice Moore, in a Canadian court, found in this case where there was a tree straddling the boundary, only just, it was mostly on one person's, no, in fact it might not even have been on the boundary at ground level. At ground level it was on one person's land. She wanted to remove it. The neighbour said, I don't want that tree removed, and I've got an interest in that tree, it's partly my tree, and they went to court. And the judge found, well, just because the trunk at some arbitrary point, that is where it enters the ground, is on your neighbour's land. Actually, most of the trunk, once it comes above the ground and it went on a lean over the boundary, most of the trunk is shared. And so ownership is shared, therefore the person who wants to remove the tree actually can't without the permission of this person. So common law, judges have an ability to interpret the law the way they want. If they want to make a new finding like this judge did, they're welcome to. And in this case, I'm not sure, I have not heard of another case following this where that precedent has been followed. So as far as I know, most courts, and including our court, are still looking at where the tree is at ground level. So Justice Moore in that case, Hartley and Cunningham, said the entire trunk, not only some arbitrary, not arbitrary, arbor or tree, that's my joke, some arbitrary point where the trunk emerges from the ground. So like I said, if you want something to take to bed at night, look up Robson and Leschke. There's a case law website that I put down the bottom there. Feel free to look that up and have a good read. It goes for a long time, and you certainly should be asleep by the end, but then when you wake up you can read some more. Thanks for your time.